My name's Walt Clyne. Most of you know me. I'm the general manager of RE/MAX United, and today we're going to do a webinar class on the recent forms release, the June forms release, where uh, 2 new forms were released, and I believe 6 existing sales transaction forms were revised. And so I'm going to talk about each of those forms and give you an overview of the changes. All right, the new and revised car forms, June 2020 release. And in this webinar, we're going to talk about the sales transaction forms only, just the forms that pertain to your sales transactions. So the first form that is a new form that I want to talk about is the property visit and open house advisory, the PVOH form. That is a brand new form and has some significant benefits to being used by both listing agents and buyers agents in their transactions. This form is not at this time required by either RE/MAX United or RE/MAX All Pro, but that could change moving forward as we get more and more comfortable with the benefit of this form. But it's highly recommended, whether you're a buyer's agent or a listing agent, to include this form in your transaction. And in fact, as a listing agent, you can include this form in the MLS and ask buyer's agents to have their buyer acknowledge this form by signing it. The visitor down at the bottom, what they mean for the most part in sales transactions are the buyers who are actually accessing the property. Okay, so let's go through the details of the PVOH. They have, there's 5 specific clauses, and each one has a specific purpose and benefit. The first is the clause that discusses recording devices. And it basically states that the property may contain audio and video recording devices. And the significance of that is the visitors may be being recorded during their visit. So both what they say and do may be recorded, and that information, of course, would be available to the seller. So the buyer is advised that their conversations might be recorded, and the impact of that is, of course, we expect our buyers and our, to behave professionally inside the property. So we're not as concerned about that. We are concerned about perhaps the buyer and the buyer's agent discussing negotiation strategy while in the property, which could compromise their ability to negotiate once they put in an offer. So this clause is a very, very helpful clause, especially to buyer's agents. It also is helpful to the listing agents because it does put the buyers on notice that they're being recorded. There's some concern that buyers' privacy is being invaded if they're being recorded without their permission. So this clause covers that. The next clause talks about safety, and it makes a point that the visitor, the buyer, is not familiar with this property in all probability. So there may be steps and stairways and things like that they're not familiar with, and tripping or something like that could occur. There also may not be handrails, for example. The seller is, comfortable going up or down a single step without a handrail. And so there isn't one, and that could be dangerous for the buyer. So this puts the buyer, the visitor, on notice that there may be hazards in this property they should be careful of. And it also talks about if the buyer is asked to remove shoes, that the lack of shoes may reduce their traction, and they could slip and fall. So a nice advisory there. The next clause talks about animals or pets, and it talks about basically the pets may be unpredictable, so you should use caution around the pets. And it even mentions the fact that if the visitor, the buyer, has allergies, that they could be affected because there may be pets in the home. The next clause talks about minors, and it points out that the visitor is responsible for the conduct of the minors within their property. So, good thing to point out. And then finally, there's a general statement that the visitor, the buyer, assumes all risks of injury when they enter the property. Now, just a comment, sellers should still be careful about not creating hazards. And if you have a specific hazard, it should be disclosed. There was a lawsuit a few years ago where the seller knew they had a pull down ladder, access to the attic, and they had a pull down ladder, and they knew that the ladder was rickety and not really safe, but the owners didn't go into the attic much, and so they didn't repair it, but they were aware that it was dangerous. The buyer wanted to see the attic, the visitor, while they were viewing the property before entering into contract. They weren't even under contract. They were simply a prospective buyer. They pulled down that ladder to go into the attic, and of course, the ladder failed, and they fell, broke their hip, went to the hospital. They successfully sued both the listing agent and the seller for failure to disclose an obvious hazard. So I would caution listing agents to be aware of the fact that this form does not absolve the listing agent or the seller from specifically pointing out any specific hazard your property might have. I remember when I was showing property, you can't see me now, but I kind of gave a little shiver. I showed a property where the seller had pet snakes, including venomous snakes. And I was aware of it, wasn't too happy about going in there. I don't like snakes, but at least it was in the MLS to be cautious. The fact that I think they had them in one of the bedrooms. They had aquariums with snakes, including rattlesnakes. So anyway, point out or disclose any obvious hazards. And then this form is sort of a general form that, sort of covers, gives a broader range of coverage. Okay, the next form I want to talk about is something that comes up all the time, and that is square footage and lot size discrepancies, or not discrepancies as much as maybe a better way to say it is multiple sources and multiple numbers, if you will, for what square footage or lot size is. So in other words, the appraisal says one thing, the builder's brochure says another, the tax rolls maybe even says a third thing. And so I frequently get called by agents, which square footage should I use? And the best answer is you can use any square footage that you can support with some backup document. And obviously a listing agent and a seller are going to want to promote the highest square footage. And there's nothing wrong with that as long as you have a document that you can quote that says that higher number. And so the nuance there is, if you think about it, is the listing agent isn't giving the higher number as much as he's saying, according to the appraisal, the square footage is X. And that's accurate, whether the square footage is in fact X or not. So you can give a higher square footage, but always attribute the source of the square footage. And in the MLS, you should state that there are additional sources of square footage that may vary, and then provide that information. If you don't provide it in the MLS, you absolutely must provide it in the sales transaction. And so this form is the form that you accomplish that with. So let's review the form. It's, again, not required at this time, but I would highly, highly recommend this form whenever you're involved as a listing agent or a buyer's agent for that matter, and you're aware that there are different square footages for this same property from different sources. So the first paragraph talks about the fact that there is no official square footage. The assessor's square footage is simply a square footage that is used as part of valuation of the property. The A buyer may have other different square footage. I'm sorry, the seller may have other additional sources of square footage. No single source is the official source. So the buyer should not rely on any advertised or disclosed square footage, but retain their own expert to measure the square footage. So a similar set of points are made when it comes to lot size, and with the addition that fences, hedges, walls, other such features of the property may not correspond to the actual boundaries of the property. And in fact, existing structures that appear to be on the property may not even be located within the property. I'm familiar with a transaction one time where a storage shed, which everybody believed was part of the property, when the property was surveyed, they discovered the shed was actually on the adjacent property. So there's a good form to point this out. And again, buyers should independently investigate the lot size by hiring a licensed surveyor if that is of concern to them. The next section of this form, section 3, paragraph 3, is where the listing agent and the seller, and you probably work together, actually list the various sources of square footage and what the square footage or lot size that those sources provide. And then any additional information that you want to put here. And then finally, check the box if you're providing a copy of that source. So this is a very important section to fill out where you have multiple square footages. Many of the houses that I sold, when I sold real estate, there was only one square footage. The tax roll and the builder square footage correspond exactly. It was a typical suburban neighborhood with a handful of builders that built specific models. So in that case, there was always just one square footage for the house. And so if you have that situation, this form is not so important. But where you have more than one square footage, this form becomes important. The next clause, very important. In fact, the next two, it is that the broker is not going to verify any of the square footages provided. So quote your source, provide a copy, but you're not responsible to verify whether that source is accurate or not. And again, the buyer is strongly advised that if they have any concern about the square footage or the lot size, they should do an independent investigation, and that the brokers are not the source of that final absolute number. The seller signs this, so the seller is representing they're not aware of any other measurements about the property. So it's important if the seller knows he's got an appraisal that has a smaller square footage and he wasn't too happy about it, he needs to be sure that he tells his listing agent, you as a listing agent should ask, because the seller is representing when they sign this form, they have no other square footage documents, if you will. I just want to make a quick comment about this form and square footage in general. Many of you are familiar with a major lawsuit, Hornicky versus Coldwell Banker. And you're probably familiar, if you are familiar with that, you're familiar with the fact that it addressed dual agency. And it had what I always believed was going to be an obvious outcome, and that is if the same brokerage represented the buyer and the seller, then both agents were in fact dual agents. The fact that a buyer's agent is only working with the buyer and the seller's agent is only working with the seller, that does not make them exclusive agents of those particular parties if the brokerage represents, is the broker for both entities. So if Remax United or All Pro, if one agent at All Pro represents the buyer and another agent at All Pro represents the seller, what the Hornicky versus Coldwell Banker clearly stated, and I wasn't surprised, most people who were knowledgeable about dual agency were not surprised. Dual agency is broker specific. So I always like to tell agents, never tell a buyer that you represent the buyer only when you're selling a RE/MAX United listing. What you should use, the phrase you should use is work with. I'm going to work with you only, because a buyer is as much the seller's agent, a buyer's agent, I'm sorry, is as much a seller's agent as he is a buyer's agent if the brokerage represents both. And the reverse is true. The listing agent is as much the buyer's agent as the agent who's working with the buyer, if the same brokerage represents both. So that's what Hornicky clearly established. Now, why am I going into the weeds about dual agency? It's interesting to me to note that the lawsuit was brought because there were multiple square footages for the property. The listing agent was aware of it. The buyer's agent, both of them working for the same Coldwell Banker brokerage, the buyer's agent was not aware of it. So the buyer sued under a breach of fiduciary duty. Now, the buyer's agent was a personal friend of the buyer, so the buyer chose not to sue their own, agent that worked with them. And Coldwell Banker didn't want to bring one of their own agents into a lawsuit they already had with a different agent. So the buyer's agent, who I would argue dropped the ball, was excluded from any liability. And the listing agent claimed that he didn't represent the buyer. He worked with the seller, so he only represented the seller. Hornicky versus Coldwell Banker said, no, same brokerage, you're a dual agent. And the issue was over square footage. The listing agent was aware of several different square footages and only advised the buyer that he should confirm what the square footage is, and didn't provide those additional square footage documents or information about it. So pretty important. Coldwell Banker paid hundreds of thousands of dollars in liability for that. So this form is pretty important when there are more than one square footage for a property. All right, let's talk about the next form. And the next form that was revised is the RLA, the Residential Listing Agreement. And what was not revised is page 1. So why am I showing you page 1 with all my red marks? I want to take this opportunity to point out two things that I frequently see agents either misunderstand or overlook. And it's to the agent's detriment, the listing agent's detriment. So the good news is I'm sure that in All Pro, Mary and the people who check the files at All Pro are paying attention to this. And I know that Lindsay in RE/MAX United, when she sees these mistakes, she brings them to my attention so I can contact the agent so we can correct them. So what am I talking about? Well, the first mistake that is sometimes made more often than I'd like to admit is on the compensation to the broker relative to the commission that the seller's paying. So we're talking about paragraph 3A and 3D. So here's what I want to be sure everybody understands. 3A, this number that goes in here, if it's a percentage, is the total commission, every penny of it. The commission that the listing agent is going to keep, and the commission that the listing agent is going to provide through the MLS to the buyer's agent. So if you're taking a 6% commission, good for you, a listing, a 6% commission on a listing, and you're going to give 3% to the buyer's agent, 3 does not go in this number. The fact that you're keeping 3 is not what this clause says. What this clause says is the entire commission is 6. And so if an agent put 3 here and 3 here, because paragraph 3D is where an agent states how much of this commission in 3A they're going to give to the buyer's agent, the cooperating agent. So if you put 3 down here in paragraph 3D and you only have 3 in paragraph 3A, what you're saying is, I'm going to give all of my commission to the buyer's agent. I'm pretty sure that most of you, or at least your spouses, feel the same way or feel the same way that Diane felt. Diane was not too happy if I gave all my commission away. So don't give all your commission away by making these numbers, this number be your commission and this number be the buyer's commission. This top number is the entire commission. Now, one other point that I see that sometimes agents make a mistake, and that is when they're going to charge money in addition to the percentage, they put the money on this blank. Why? Because it's a dollar sign there, and it makes sense. Well, I'm going to charge 6% plus $300 or $400. So they write 6% here and write $400 here. That's a mistake because look at this word in front, or. I'm paying 6% or, and when there's ambiguity, it gets interpreted against the creator. So you, as the listing agent who created this document, if a seller got angry with you during the transaction and decided they wanted to somehow beat you up on commission, and you put a $400 number here, you would lose if this went to arbitration, because the or means they're exclusive, and you created confusion by putting one in each blank. So if you're charging $400 in addition to your 6%, put it under the end line. Now, most agents know that. Some agents don't realize it. Why? Because there's no dollar sign here. So they just automatically put it up here in front of the dollar sign. Don't do that. Put it down here. One additional comment. I don't want to get into the weeds about charging transaction fees. That's for another webinar. I know a lot of agents add to the commission they're collecting, the 6%, that portion of or an amount of money that they're also paying a transaction coordinator. That could be problematic if you identify that as what that fee is. RESPA allows you to charge a transaction fee. They used to not, but there was a lawsuit that allowed it, but not universally. There are certain circumstances where you're not allowed to do that. More importantly, the state of California has a civil code that says real estate agents cannot charge a duplicative fee. So can you charge a commission of 6% plus $400? Yes. And if you want to use that $400 to pay the transaction coordinator, there's nothing wrong with that. You use part of your commission to pay your mortgage, to pay your credit card bill, to pay your automobile lease, put groceries on the table. So you can do whatever you want with the 6% plus the $400. Just do not put transaction fee on this line. That is problematic. Now, we're trying to be as lenient about that as possible because we understand you get beat up on commission, and so you're trying to cover some of your costs. And Cheyenne and Kenny and all of management understands that. I just don't want you to create a situation where if it became a dispute, you would lose, because you would if you wrote the word transaction fee on this blank here. Don't write it. Just charge $400 in addition to your 6%. Okay, that takes care of one of the items. The other item, and that is how to put commission on the RLA. The other item that I see often, well, not often, I see sometimes to the listing agent's detriment, is a mistake on paragraph 3A2. And that is what most of us call the protection clause. The protection clause allows you to reserve the right to be paid compensation if a buyer or the buyer's relative who entered the property during your listing period ultimately bought the property afterwards. And so, that's not an indefinite forever right. So, because the law requires that there be a termination of all contracts, so you have to put a number in here. I tell agents to put at least 180 days in there. And if your listing is longer than 180 days, you could put that in too. It matches the listing period. But 180 is a nice minimum. I've seen people put 30 in here. My gosh, a buyer and a seller could conspire to not do anything for 30 days to get around paying you a commission, but they're probably not going to do something for 180 days. So put 180 in there. If you leave this blank, this paragraph doesn't even apply. So first mistake, put a number here. The next mistake agents make, and this is understandable, especially experienced agents, because the old RLA stated that you had 3 days after the end of the listing period, after the expiration, after the cancellation, to provide a written list of prospective buyers. That was changed, again, as a result of litigation. Uh, and you have to provide that list prior to, it says here, no later than the end of, which is another way of saying prior to the end of the listing period. So if your listing is expiring tomorrow, get that list to the seller today. If you get that list to the seller the day after tomorrow, it's not, the paragraph 3A2 will not apply. The protection, the people on that list, named on that list, it won't matter. So those are two little things. I digressed a little bit from the revised portion of this webinar. But I want to take this opportunity to give you a heads up on what is sometimes a mistake that some agents make. Okay, so let's talk about the revisions to the RLA. There are several, so let's go down and take a look at them. The first one is not a real big thing to concern yourself with, but CAR did two things. They streamlined, improved, and reformatted paragraph 5 and 6. Paragraph 5 talks about what a multiple listing service is. It discusses it a little bit, and paragraph 6 talks about the benefits or the impact of opting out of an MLS. And so they streamlined, especially paragraph 6, quite a bit. They moved a few things out of paragraph 6 into paragraph 5. And so, if you're familiar with the old form, you're familiar with the new form, with one exception, and that is they discuss in paragraph 5 what the brokers, which means you, what MLS are you a member of? And so you would list here the MLS that you're a member of. Most of the RE/MAX United agents are going to list San Diego MLS, SD MLS, and I think Lancaster and Palmdale are going to list the Gavar. There may be others, but you list at least one that you're a member of. And then if you're a member of an MLS in an area that is not the primary MLS for that area, you need to check this box. So not a significant change, but be aware that that blank should be filled in with what is your MLS. Now, the significant change on the RLA is the public marketing of property, which has to do with the clear cooperation policy, NAR's new clear cooperation policy and rules. So I want to review that with you briefly. The first clause talks about whether or not the MLS requires clear cooperation. And I can tell you both Gavar and San Diego MLS do require it. The only MLSs that can not require are private MLSs. There are a couple of them in the state of California, but SD MLS, Riverside MLS, Gavar, Orange County, all of them do require that the agent adhere to the clear cooperation policy. So you would not check this box. That box remains unchecked. Okay. Now, the next clause just simply talks about what public marketing is, because the rule is that the MLS, the property must be submitted to the MLS within 1 business day of public marketing. And most of you have probably reviewed the clear cooperation policy, and you're familiar with the fact that public marketing is very, very broad. Signs are public marketing. Any digital marketing is public marketing. Mailing flyers out or putting information in an email blast is public marketing. Okay, the next clause is one that you want to sort of review a little bit with your own manager as to how that is impacted in your area. The different MLSs have coming soon statuses, but the coming soon statuses are not universal MLS to MLS. So what CAR says, since this is a statewide form, is that the broker should uh, or the seller rather, should review with the broker the coming soon status and what's allowed and not allowed as a result of uh, uh, coming soon. And it provides a provision where the seller can, the default is you may place the property in coming soon and not put it in immediately in the MLS. If you do not, if the seller does not want you to take advantage of the coming soon opportunity, then this box should be checked. Now, the other thing about the clear cooperation and the coming soon policy is that the seller is reminded. Well, first of all, the seller instructs the buyer not to market the property until such and such a date. So if the seller is withholding the property, if the listing agent has and the seller have agreed to withhold the property from the active status in the MLS, then you put that date in there, and then you can put it in coming soon uh, if the previous box was not checked on paragraph 7C. So if that's not checked, you can put it in coming soon, but you're not going to put it in active until the date that you put right here. And then finally, the seller is advised that well, first of all, the seller instructs the property not to be marketed to the public at all. And they're again reminded that if it does get marketed to the public, it must go into the MLS within 1 business day. Paragraph F does not apply, I would think, for All Pro or Remax United because all of our MLSs rather do contain clear cooperation policy rules. All right. Moving on, there are a few relatively minor changes, but they're significant enough I want to mention them to you through the balance of the RLA. The first one is they put in the RLA something that's already in civil code, and that is that the broker will present all offers on the seller's property. Civil code requires that if you receive an offer, even if it's the day before closing, you're to inform the seller that you've received the offer and present it to the seller unless the seller has given you a written instruction not to. We don't often get offers a day before property closes, but sometimes we get an offer shortly after the property's gone into escrow. We're still required to present them unless the seller says, I don't want to bother, I'm happy, I'm in escrow, hang on to them if we need them, but don't bother. Well, then have the seller give you an instruction in writing, an email suffices. Please do not present any additional offers to me at this time. Okay, so that's paragraph 10B. Paragraph 10D states that that it had always stated that the seller authorizes the listing agent to pre-order, if you will, certain inspections and reports. And they listed the pest control, so you can get a termite inspection ahead of time, sometimes very advisable. That way, when you do get offers, you know what you're up against in negotiating. Some agents actually have their sellers agree to get a physical inspection of the property. What they added, which is a very, very beneficial addition, is the seller can authorize and agree to pay for the homeowner association documents in advance. Why is that important? Well, if you've ever sold a condo, homeowner associations are very slow, even though civil code says they got to get them out in 10 days, which is interesting because we're required to provide them within 7 days. And even so, the homeowner associations take 2 and 3 weeks, 14 to 21 days to get them out, unless you pay extra. Isn't that interesting? One additional way for HOAs to, reach into the seller's pocket and collect more money. So a listing agent should, at the very least, discuss with sellers whose property is governed by a homeowners association that ultimately the seller will be required to provide those documents to the buyer. You cannot exempt yourself from the certain documents, sort of the basic list that they are in civil code, and the civil code says the seller has to pay for them, not the buyer. So there's no real reason to wait to go ahead and get those documents, especially if your house is priced right, you expect it to get an escrow within the next month or two. get those documents early and avoid paying a rush fee, additional cost to avoid additional delay. So that was added to the RLA, a discussion of that, a brief discussion, and the authorization to do that. And I would advise listing agents to discuss this with their sellers when they take the listing so that they can address that issue. The next change is the fact that the seller agrees. It's interesting. Was never a part of the listing agreement, although we always did it. The seller authorizes the broker to let anybody into the property to facilitate the sale. And so we're going to let inspectors in, appraisers in, repair people, and we are pre-authorized to do that now in the RLA, which is a nice clause to add to the RLA. All right, I believe that completes the changes to the RLA. Let's talk about the next document that has been changed, and that is the seller instruction to exclude the listing from the multiple listing service known as the SELM. And that corresponds pretty much with the changes in the RLA. So I won't go into a lot of detail about this form. I underlined in red all the changes so you can see that it was updated quite a bit, but it was mostly updated as a result of the clear cooperation policy. And so this form discusses how the clear cooperation policy impacts whether or not you can exclude a property from the MLS. And I won't repeat much of what I told you with the RLA, but you can go through that. And once again, it does contain a provision where the seller can instruct the listing agent. The seller can instruct the listing agent to exclude the property until a certain date, or for that matter, the entire listing period. So A and B are exclusive, mutually exclusive when you check those. Okay. The next form I want to talk about is the TDS, and there's only one change in the TDS, and it may appear minor. It is significant. It's an interesting change. I won't get into the weeds too much, but what transpired as far as changes in the TDS have sort of an interesting background. Let me share with you. Here's the change. They added this box: no substitute disclosures for the transfer. The TDS prior to the revised TDS only had two boxes. Now, here's what's interesting. Civil Code has stated, and it still states, that the seller on non-exempt properties must provide a TDS. It must be complete, and all three sections must be completed. And if they are not completed, then TDS has effectively not been delivered. So the problem in the past was nobody really realized it because most agents didn't pay much attention to Section 1. The three sections of the TDS, as you're all aware of, Section 1 is coordination with other disclosures. Section 2 is the seller provided information. And Section 3, of course, is the information that the agents provide to the buyer. So let's go back to Section 1. Section 1 did not used to have this box, and yet Civil Code said you had to complete Section 1. So you either had to say, I've got some additional reports, inspection reports, that were completed prior to this sale, or here are some additional disclosures. I mean, what if you had neither? So that's basically what they added, sort of a neither box. Now, here's why I'm pointing this out to you. It is clear, and I've discussed this with car attorneys, and even the lead counsel for car has stated that if Section 1 is not complete, the TDS has not been delivered. And a buyer, regardless of whether they've removed contingencies or not, because you cannot waive delivery of a TDS on non-exempt properties. In other words, properties that are not exempt from providing a TDS. You can't waive it. So if you've not completed all three sections, the Civil Code says you've not effectively delivered the TDS. So you ignore Section 1 as the listing agent, and the seller's not going to really pay much attention to it, although I'm going to share with you a document in a minute where the seller's advised to pay attention to it. But if you ignore this and no box is checked, the buyer's removal of contingencies could be reversed, have no effect because you've not delivered a TDS. And Civil Code also says that a buyer has a right of rescission for up to 5 days after delivery of the TDS if it's by mail or email, or the contingency period, whichever is longer. So you go through the whole transaction and you never recognize this mistake, you run the risk that at the last minute the buyer wants to bail, and if he has a smart buyer's agent, the buyer's agent is going to say, well, you never gave us a TDS that was completed, so we're going to cancel. And if you give us a TDS that's completed, I got 5 days to cancel. So I hope I haven't confused you. I want to point out, just make sure, look at your TDSs that have already been completed, go back to the seller and instruct them to check one of these boxes. And most likely they're going to be checking this one. If you were already in escrow and it fell out of escrow and that buyer got an inspection report, well, then you might be checking this one and listing the physical inspection report here. So then you're okay. You don't need to check this. In fact, you wouldn't check this. But if you haven't checked any box, be sure one of those boxes is checked. Hopefully that is pretty clear and helpful to you. Now, on the same vein, something I will point out to you because it has the same impact. The agent, especially the listing agent, it could be argued the buyer's agent can't use this gotcha as a way to help the buyer bail out of a transaction. But the listing agent must check one of these boxes. So again, if the listing agent didn't check any box, it's maybe not as easy an argument to make, but it could be made. The TDS has not been completed because all sections must be complete. And Section 3 wasn't completed. There's an additional civil code that sort of exempts a seller from being harmed by a buyer's agent who uses a little, an amended disclosure as a way of facilitating the buyer getting out of a transaction after contingencies are removed. Specifically, what it talks about is if a buyer's agent delivers an AVID after contingencies are removed, the buyer cannot cancel pursuant to that AVID and get his deposit back. I mean, he can always cancel, but he would not necessarily be entitled to a deposit back, even if the AVID contained information the buyer was uncomfortable with. Why? Because the buyer's agent provided it late. So the court would say, no, you can't cancel, but you can sue without losing your deposit, and you can sue your own your own agent, the buyer's agent, for that deposit, because if that AVID concerns you, the buyer's agent was required to give it to you earlier. But they're not going to penalize the seller for this late delivery of the AVID by the buyer's agent. So getting into the weeds a little bit, but perhaps the message you take from this is pay attention to these forms, make sure they're complete, and for goodness sake, don't shoot the messenger when whoever checks files at All Pro and when Lindsay or whomever is checking files here at RE/MAX United and alerts you to something that's not complete, they're doing it for your benefit. So thank them for being diligent, and know that if you correct it, you are avoiding future trouble. All right, the next form that was revised is the DIA, and it's on, the Disclosure Information Advisory. And at RE/MAX United, we require that this form be delivered to the seller prior to the seller filling out disclosures, because this contains important advice to the seller about how to fill out disclosures. I'm not 100% sure if All Pro requires it or not. with a smile, I'm going to tell you they should. And I'm going to tell all the all pro agents, you should be sure your sellers get this form. Now, buyer's agents are not required to have this form. This is an advisory to the listing agent. So this is not a required form in the transaction folder when you represent the buyer only. Okay, now the change on the form is specifically what I just talked about regarding the TDS. That section 1 must be complete, and one of the 3 boxes must. It doesn't say should, it says must be checked. Why does it say it must be checked? Because civil code says that if that section 1 is not complete, you've not delivered your TDS. Okay, so sellers should make sure that they check a box, and most likely they're going to check there's no substituted disclosure for this transaction. Okay, the next form I want to talk about is the SWIPI, what we call the SWIPI, right? And the SWIPI, where to go with it? I'm sorry. The septic inspection, well inspection, property monument, and the new change and propane tank allocation of cost addendum. So the propane tank is a change in the title and a change in the form, but there are additional changes in the form. Let me talk about them quickly here. The first change is that they added to the septic section a website that the buyer can go to get information about septic systems. I can tell you, I've talked to a lot of clients, a lot of agents that are sometimes involved in their first septic transaction. If you're an agent in the Scripps Ranch office, you can go your whole career and never sell a house that has a septic. If you're an agent in Fallbrook, you probably sell septic houses with septic systems far more often than you do on ones that are on sewer. So the point is that if you've never been involved in a septic system transaction, and the buyer's never been involved in a septic system transaction, they may have a lot of questions. And so they wisely put a website here that the buyer can go to, and they get a lot of information about septic systems. So that's a nice plus. Point that out to your buyers, especially when you represent buyers, that they should pay attention to that. The other thing that's a change, and this is a significant change, the old form simply said either the buyer or the seller would pay for the cost of locating and accessing the system. Here's the problem with that. Those of you that are familiar with septic systems, sometimes it's a problem to even find the tank, but usually you can figure that out. What's more problematic is where's the leach field? Now, there's an old joke, the grass is always greener over the septic system. So you might be able to find the leach field by seeing where the nice grass is growing lush and green. But what happens if your property has no grass, right? So identifying the leach field, and the leach field is part of the septic system, could be costly. Now, usually, and not always, but usually what's really of concern is find the tank so that the lid can be removed and we can pump it and inspect it. And they usually ask the seller to pay for that, not required. And so if it is only going to be the tank, check this box. I would say in most cases, if you represent the seller, you're going to probably want to counter that this box should be checked. I can understand that a buyer's agent is not going to limit it to tank only to give the buyer as much protection as possible. But the listing agent could then counter back that regarding location and assessing the septic system, seller will only pay for locating the tank only. Okay, so that's a change. Now, this next section here is not a change to this particular part of the form. And what that says is that if the inspection reveals that there needs to be money spent to certify the system, to make repairs so that the inspector can say it's working, that the buyer and the seller are to negotiate how those repairs are covered. The seller is not automatically liable for making those repairs, spending the money, unless there's a second agreement that allows, that the seller allows for the fact that they will pay for. And if that agreement can't be reached, then either party may cancel the agreement. So that's a seller protection clause. It's been on the SWIPY, I think, since the SWIPY was created. It was a kind of clause that was not on the old termite addendum, and so that's why Carr got rid of it. Rather than adding a clause like this, they got rid of it because a lot of times sellers were inadvertently committing to paying for termite clearance when they had no idea what the expense of that would be. So this is a protection for the septic system. They added this clause to the well inspection as well. This clause was not in the well inspection. So if the buyer is asking for the well to be checked and certified that it's good, clean water, and the report comes back, no, it's not, and you got to spend some money to take care of it, then they have to enter, the buyer and the seller have to enter into a second agreement as to who's going to cover the costs. And if no agreement can be reached, either party can cancel the agreement. Again, it protects the seller from agreeing to something they don't even know what the costs are. So be aware of that. Now, the next thing on this form, on this WIPY, is new. And what is new is the propane section. And I'm so glad to see this on there. Can't tell you how many times I get calls because now escrow is closing and there's an argument about the propane in the propane tank. Whether or not the buyer owes the seller owes the buyer. How's that work? So I'm not going to tell you how it used to work because it won't matter anymore because there's now a SWIPY. If there's no SWIPY, then call me and I'll tell you how it works. Okay. So the propane section that contains, first of all, a statement as to whether the tank is leased or owned. My understanding is most tanks do tend to be leased, but that's something that should be determined. And then one or both of these boxes may want to be checked. I mean, I'm not telling you they have to be, just showing you that they may want to be. The first box simply says that the propane in the tank will be measured prior to the close of escrow. So the amount of propane left in the tank will be measured prior to the final walkthrough. Now, if that's the only box you check, I can tell you that the propane in the tank is real property. So the buyer has no obligation to pay the seller for the amount of propane that's in that tank. That's the issue that comes up. A lot of people don't realize that. Sort of think about, does the buyer have to pay the seller for the amount of water that's in the hot water heater? Does the buyer have to pay the seller for the amount of water that's in the pool? I mean, I could take it to an even greater extreme. How about the water that's in the toilet tanks? No. The minute they become in the tank, they go with the property. So if it's not predetermined that the buyer will reimburse the seller, the seller's not going to get reimbursed because that goes with the property. So the propane clause was added to this to, among other things, allow for the seller to say, the buyer to proactively volunteer, look, Mr. and Mrs. Seller, we'll pay you for whatever propane's in that tank that is in the tank when we acquire the property. So as a listing agent, you're probably going to want box 1 and 2 of 4A check. Not required, but certainly allows for the seller to be reimbursed. There have been circumstances where the tank was filled 3 days before escrow closed. It was on an automatic, refill type thing, and nobody bothered to tell the propane company, hey, don't fill it. And suddenly the seller was stuck with a bill, and the buyer had no obligation to pay the seller. So this is a pretty important clause. Okay, now I think the final form, if I remember right, yes, the final form that I want to talk about, and these are, I'm just talking about the sales transaction forms, is a representative capacity signature disclosure and what additions have been added to it. So this form, it is not a authority document. It does not replace the fact that you need a copy of the power of attorney, or you need a copy of the trust, or you need a statement from the LLC that the person signing the document has the authority to bind the LLC. You still need that. That's often a confusion, that people sometimes think this is the authority document. It is not. It simply protects the person who's signing on behalf of the entity, whether it be the trustee or the attorney in fact who holds the power of attorney, or a member of the LLC. It protects them from being individually liable because their signature appears on the document. So this is an important document to protect the buyer, and especially the entity who's signing on behalf of the entity he's signing for. It's not the authority document. And what's been added is an additional acknowledgement of receipt, because this form was redesigned to make it, give it multiple uses. So depending on what's going on, you can simply send the same form and have people who are now affected by the change signing that they acknowledge receipt. So what I'm saying here is, if the transaction has an assignment in it, so the form was probably delivered to the original purchaser, and now the purchaser has assigned and the seller's agreed to the assignment to a new purchaser, then you want to give this form to the new purchaser, the person who took over the assignment, and here's a place for them to sign that they got a copy of this form. Okay. Folks, that completes the changes and revisions in the new forms to your car documents relative to sales transactions. There were some changes to some rental documents, but this webinar is not going to discuss those. I just wanted to cover the sales transaction documents. Hope that answers your questions, gives you a little insight, maybe makes it a little easier to do that tough job of representing buyers and sellers that so many of our agents do so well every single day. So I hope you found this webinar useful. I want to thank you for joining me. As always, if you have any questions, reach out to either your manager, or you're welcome to reach out to me at RE/MAX United, and I'm happy to help in any way I can. And with that, I'm going to say goodbye and take care.